Afternoon, Mkuna.
Well, okay. I think we can get started. It's time. Last week, we were busy with study unit 3, Antinuptial Contract. And if I'm not mistaken, I think we went on up until time for registrations. You will correct me if I'm wrong. Okay, so let's. Okay, so time for registration, I think we've discussed that. We proceed to place of registration. Do we have any questions before we proceed, colleagues? Any questions? Are we happy? Okay. So basically, antinuptial contract, it can be registered anywhere in the country, any deeds registries, it can be registered. However, if, for example, there is a donation, a movable property donation, or a party is donating immovable property to the other spouse in the antinuptial contract, it is advisable to register the antinuptial contract where that immovable property is situated. For an example, if the property is situated within the jurisdiction of Pretoria Deeds Registries, then you'll register your antinuptial contract in Pretoria. And then we proceed to transfer duty. So if you donate a movable property, yes.
Ma'am, sorry. You just said it's advisable. Is it advisable or it is mandatory? Or it's a must that it must be registered in that place?
Okay, what do you guys think? Can others contribute?
It's not a must.
Okay, anyone to add to that? So if you go to page 38, yes, you can go ahead.
Yes, ma'am. My question stems from that second paragraph of page 38.
Yeah.
I think it's the last sentence where it says if the antinuptial contract creates or transfers a real right in immovable property, such a copy must be filed in the deeds registry, serving the area where the immovable property is situated.
Okay.
I think that's where my clarity seeking is coming from.
Okay. So maybe perhaps we need to read from the whole paragraph. If any act of registration in respect of which proof of antinuptial contract is required occurs in another deeds registry than the registry where the antinuptial contract was registered, a copy of the contract certified by the registrar or a notary must be filed in that deeds registry. So I'm not sure if you are answered. You can register your antinuptial contract in another, let's say the property is situated in Pretoria. You can register your antinuptial contract in Cape Town. However, you have to file a copy of that antinuptial contract in Pretoria.
I understand, ma'am.
Yeah.
I understand.
Okay. Do you have any other question? Okay, let's proceed. So transfer duty is payable where real rights are acquired in a movable property. So also in this case where a movable property has been donated through the antinuptial contract, that donation will attract transfer duty, and the transfer duty will have to be paid at or within 6 months from the date of acquisition of that real right, which is the date of the antinuptial contract. Even though the property might not necessarily be transferred to the person entitled thereto, but your transfer duty has to be paid within 6 months from the date of acquisition. And we don't have stamp duties anymore. It's been abolished. Questions so far? Okay, so what do you understand by accrual system? Guys, you must remember this is a discussion. I'm not here to lecture. We must talk.
So wouldn't the accrual, ma'am?
Yes, go ahead.
Yes, Jacques. Wouldn't the accrual be a difference between, so just bear with me.
Okay.
So in the estate of one spouse, let's say one amount is the net value of his estate. At the dissolution of the marriage, where it exceeds the net value of his estate at the commencement or at the time when the marriage started, wouldn't that be the accrual?
Okay, anyone to add or disagree with what Jack has said? Come on, guys. Does it mean you didn't prepare before coming to this meeting? Yes, Dupsa. You can go ahead.
Oh, sorry. Can you hear me, ma'am?
Yes.
Yes, I was just saying in my understanding, accrual is the gain of an estate. So if marriage is in community of property, then it is the gain in the estate of both parties, the difference between the amount.
So before you proceed, you said if a marriage is in community of property or out.
Sorry, out of community of property.
Okay.
Yes. So it is the gain from what either party had at the beginning of the marriage, the difference between that amount that they had at the beginning, the value of the estate, sorry, at the beginning of the marriage, and the value of the estate at present. Okay. Whether at present be divorce or whether it be a particular point in time.
Okay. Anyone to agree or disagree?
I might agree, and I think he's on the right track in terms of what he stated. Mm-hmm. But I'm just not sure if one should just factor in that it should be the net value. So the accrual should be the net value in terms of, as he explained, which was very great, I think, at the beginning of the marriage. In this case, if we are talking about marriage, and at the dissolution of the marriage. So you need to look at the net value in terms of those two starting and ending points, isn't it?
Yeah, you're correct. It's the growth where parties are married out of community of property. And remember, accrual system does not apply automatically. Parties have to be specific that they want accrual system to apply to their marriage. So accrual will be the growth of the respective estate, which you will take into account at the dissolution of the marriage, be it divorce or death, or whatever reason. All right. So if your accrual applies to your marriage, then at the dissolution of that marriage, you're going to look at your antinuptial contract and say and check whatever the parties have decided how their estate are going to be dealt with. Right. So let's say according to the antinuptial contract, it says that they will both benefit from each other, or whichever estate that has shown growth will have to compensate the other spouse. Let's say we started from zero, both spouses had zero at the beginning of the marriage, and at the dissolution of the marriage, the husband's estate has grown to 10 million rand, and the wife's estate has shown 5 million rand estate. Therefore, there's a 5 million rand difference. So the 5 million rand difference, we're going to divide to equalize the respective estates. I think that's the short of it. So you will read there and see the exclusions, instances where or assets that will not form part of your accrual. Yes, Rolani.
Good afternoon, thank you. I want to check with what you have just said. What will be the reason for partners to get into an out of community of property marriage, but have with accrual? Because they're still going to share. What will you say is the reason for them to choose that type of a marriage?
Anyone to answer this question?
Can I take a chance, ma'am?
Yeah, sure.
For me, it would be if parties have their own respective properties or businesses, and they bring both those to the party, but at that particular time, they don't want to share their wealth with each other. So what they're actually saying is, or in another more direct instance, two partners can say, I want us to bring our businesses together and grow it together. So it might be an incentive for both partners to support each other to grow the business, so that at the end of the day, you don't just land in the butter when you arrive into a marriage. Is that a more better understanding?
Rolani?
No, I'm not sure. But when I think of it, I thought maybe the reason could be that the partners want to be treated individually when they are doing their business in the process of their marriage. For instance, they want their estates to be treated differently by creditors, for instance. So I wanted to hear, is that the main reason, or what will be the actual reason? Because with what he's saying, with accrual, it means they are going to share. If it was without accrual, that's where you can say they don't want to share what they have.
Look, there are many reasons why partners would want to have accrual system. For an example, or a simple one is, let's say you are married to whoever out of community of property with accrual system, and your partner tells you, Rolani, I want you to stay home, be the house executive, look after the kids. I don't want you to participate in the job market or do any kind of business. I want you to just stay home, raise the kids, look after the kids, drive them around, do school, whatever. But you are not going to work, I'll support you, right? Your partner is working, building his estate, it's growing. You are doing nothing but to look after the kids and the house. Then comes that day when the marriage has to be dissolved. Are you going to walk away empty-handed? There will be nothing for you because you did not grow the estate, right? So that could be one of the reasons where you'll say, okay, can we have accrual system? To be fair, on me, Roland, who will be staying home looking after the kids, my husband, if should it happen that we divorce or the marriage is dissolved by death, the partner will say, I want my wife to benefit as well. She is contributing to the growth of my estate, that being your husband, you are contributing to the growth of his estate by looking after the kids, looking after the well-being of the whole family. I don't know if that makes sense.
Yes, that makes sense. But I'm just asking myself, why don't you go the cheaper route of in community of property where you don't have to draw up antinuptial contracts?
Well, remember your in community of property, it means we share assets and liabilities. So let's say your husband, being a stay-home house executive, wife, mom, whatever, he's in the market, busy acquiring assets and making debts and everything. God forbid he ends up being insolvent. That means you are also insolvent.
Okay, no, it makes sense. So it means my thinking was right to say it's because they want the benefit of being treated separately from creditors, for instance.
Yeah.
Thank you.
There was a hand. How do I pronounce your name? Please help me.
Dupois,
Oh.
ma'am. But you've answered exactly what I wanted to ask.
Oh, okay.
Yes.
Okay. Do we have any other question? Can we proceed? Or anyone to add?
Ma'am?
Yes.
Just a question as to when the accrual system starts. So if parties enter into an antinuptial contract, that comes into being, as far as I understand from the coursework, when the marriage is solemnized. I hope I got that right. So when does the accrual system, if it is included, which I think it's done automatically unless you exclude it, is that also from the point when the marriage is solemnized?
Okay, so accrual system is not automatically. You have to include it in your antinuptial contract.
Okay, so it's not automatic. Yeah.
Yes, you have to expressly state that antinuptial contract will be applicable. So antinuptial, your accrual system will have effect, or it comes in at the time of the dissolution of the marriage. Remember, when the marriage is dissolved, that's when we're going to look into their respective estates.
Okay, but
the husband, has your estate grown by how much? The wife, has your estate grown by how much?
But as at the point when the marriage was solemnized, that's the growth is determined from that point?
Ms. Ramwell, please come in.
I think it's a really interesting question that I've never thought about before, but normally people will enter into the contract and get married 2 weeks later, and what does it matter? But remember now, in their contract, they say what their starting amount is. So let's say I say in my contract, my starting off amount is R1 million, and I happen to have a really big drug deal the next day, and I'm suddenly 10 million rand richer. and then a week later I get married,
Yes.
that accrual will surely show from the R1,000,000, even though I got married a week later. And remember also the contract between the parties is valid regardless of registration.
Okay, okay. That was the bit I was missing. Okay.
So for third parties, the contract is only registered when it comes into being, when it's registered, and I think they get married. But I think between the parties, if something were like this to happen, like as I say, I've got R1,000,000 now, I just have, which I say in my antinuptial contract is my starting amount. And then I have this huge, amazing, wonderful deal. I win the lotto or whatever, and I'm suddenly 10 million rand.
Yes.
And a week later we get married, and so let's say a month later we get divorced. They're going to say, hang on, your accrual was 10 million rand.
Okay. All right. Even if that took place before they got married.
Yes.
But the contract had been signed.
Yeah. Okay. Although I think, maybe I would go to court, who knows? But on the face of it, that's how I would logically argue it.
Okay. Thank you. Thanks very much, ma'am.
Okay, thank you for that, Ms. Ramwell. Okay, any other questions? All right. Okay, so on page 40, I think the second last paragraph, there's section 6(1) and 2. Please do take note of that. Yes.
Sorry if I could just pull back Mrs. Ramwell back a little bit with what she said and what my colleague was saying. And what is on page 40 on the 1, 2, 3, I think it's the 4th paragraph, which says the accrual system applies only to assets gained during the duration of the marriage. So if I get that 10 million rand from Lotto before getting married, will it necessarily be part of the accrual in view of what is in this statement?
Ms. Ramwell?
Yeah, I hear you. I hear also. That's why I say maybe one would argue this in court. But on the face of it, they would look at it and say, here's an antinuptial contract. What was the starting value? What is the end value? Here's the accrual. Okay, and then you would come and argue and say, no, but this was before the marriage. Therefore, it doesn't count. Who knows? But then why does your contract say this is what you're starting off with?
Okay, okay.
These things are never as clear-cut as they seem. Okay, I'm done.
Thank you. Okay. So I'm just thinking back to the question that Rulani asked. I think I've uploaded cases and additional resources. Maybe they are not prescribed though. Maybe those cases can also assist to understand more about the accrual. All right. Okay. And then, yes, I was referring to section 6(1) and 2. Take note of it that it does happen that sometimes parties, when they enter into the antinuptial contract, they do not want to declare the value in the antinuptial contract simply because all documents that are lodged in the deeds office, they are public information. Anyone can access that information. So if you don't want every Dick, Tom, and Harry to have access to your information, what you have and what not, so you can make use of a separate statement. The antinuptial contract will still be registered in the deeds office, but in the antinuptial contract, you will indicate that you will declare values of your estate in a separate statement, which will be filed with your notary. Right. Questions? Okay. So then we go to the amendment of the cancellation of the antinuptial contract. I think that is also straightforward. You can go through that on your own. And if you have questions, you're more than welcome to ask any questions. Okay, so now we come to the post-nuptial registration and post-nuptial signing of the antinuptial contract. What is the difference between the two, colleagues? post-nuptial registration and post-nuptial signing of the antinuptial contract. Is it because of the holiday tomorrow? The short weekend? Anyone to try? Yes, Roland.
My understanding is that a postnuptial registration, it's an antinuptial contract which has been drafted before the marriage. But unfortunately, remember there is a time period that has been set that it must have been filed by the deeds office. And then that 3 months prescribes before it is filed. Then in registering that type of antinuptial contract, we'll say it's a postnuptial registration because it is prescribed, but now we are registering it afterwards. You ask for extension from the High Court.
Okay. And then the post-nuptial signing? Any takers, post-nuptial signing? Yes, Roland.
I think in this case is as the same as the registration. In this case, the notary has that it has been drafted, but they could not execute it by the notary. They could not sign, so they are signing afterwards. So they have to also get permission from the High Court to have it signed after the marriage has been solemnized.
Okay. Anyone to agree with Rulani or disagree? Any takers? Yes.
Yes, ma'am. I think she's spot on. The only thing I maybe want to add is that there should have been a binding agreement between the parties before the solemnization of the marriage. And then the court, I think, have laid down some guidelines when they look at applications for notary before execution and the registration of a post-nuptial contract. So you must satisfy those guidelines in a sense as well, you know, good reasons why the parties did not have the agreement executed and registered. And they must make the application as soon as possible after realizing that they have been married in community of property. The application must be accompanied by a copy of the contract, I believe, and something about the rights of the creditor should also factor in there to be protected when the order is made. So only if the court is satisfied that the requirements, and I think there's 6, have been complied with, will they issue the order for post-nuptial execution of the contract before notary and the registration in the deeds registry. But I know I've said a lot, but I think that what she said is all right.
Yeah, you are correct, actually. So, okay, so I won't add anything there, but we proceed to section 21 of the Matrimonial Property Act. All right. Remember it that, okay. Remember it, back to Rulani's question. Her question was, why not, if you're going to share the property at the dissolution of the marriage, why not then just marry in community of property? All right. So it does happen that parties marry, for an example, in community of property. And later on in the marriage, they decide that this kind of regime does not suit them anymore. They want to change and be married out of community of property. So they have to make an application to the High Court to change their matrimonial property regime. And they have to satisfy certain requirements. So to give an example, not long ago, our famous, what's the name? The musician guy, I forgot his name. He changed his matrimonial property regime from in community of property to out of community of property. I'll tell you the name if I remember. The wife is Nandi something.
Oh.
Yes. Yes. So that is not because you want to deny your wife or your husband access to your property or whatever. Well, let's say we get married young, we don't know anything about the different types of marriages, or even if we know, at that time we don't see the need to marry out of community of property, for an example, and then we marry in community of property. And later on, as we grow, we start accumulating our assets and we venturing into businesses, and then you get wiser and realize it's actually risky to keep all your eggs in one basket. Then you decide, let's divide the estate. Let's marry out of community of property to protect ourselves against our creditors. All right. So then you'll make that application. You have to show to court that there's a good and justifiable reason for that application, and that you've notified your creditors. You have to publish your intentions in the newspapers and notify your creditors that this is what we're going to do, and prove to court that no any other person will be prejudiced by the change of your matrimonial property regime, should it be granted. Yes, Unati.
Good afternoon, everyone.
Hi, Unati.
So if one of the parties don't agree to the change, then obviously it can't be effected.
It can be. You have to agree. Yeah.
Okay. Okay.
But remember, if you want to do something and the one party, even if it's not your husband or your wife, does not agree to it, you can apply to court for an order compelling the other party or to override whatever consent the other party was supposed to give to you. As long as you can prove that it's in the best interest of whoever and there is a good and justifiable reasons for wanting to do that.
Okay, well, that's very interesting, this letter explanation. Thank you.
Yeah. Okay, colleagues, do we have questions? Any questions under self-assessment that you would? Yes, Rolani.
A simple one. I see in the study guide the one example of good and justifiable reason. It was that has been given was the instruction by the father of one of the spouses. But I'm asking myself, can the exact reason of saying we want to protect ourselves from the creditors, will the court allow such a reason? Will it be justifiable? As long, in this case, let's say we're able to show that all our creditors have been informed, or we try to make sure that we don't even have creditors by that time, but make sure that we issue out a statement that will give the court the comfort of saying we've communicated our decision, that anyone whom we may be owing will get to know. Can the reason of saying we want to protect our estate from creditors, can it stand as a good and justifiable reason?
Anyone to answer, Rolani? Anyone to try? Unmute yourself and speak your mind. Yes.
It's a nice one, to ask.
Mm.
But it's going to be difficult because it might seem like a selfish reason as well. But I don't know if there's any case law in terms of where you just want protection for both parties in terms of your creditors. To me, it just seems like, and I might be wrong, a little bit of a selfish reason why you want to venture into to change your type of marriage that you entered into. I do know, however, that a lot of people are misled when they get married. In most instances, by the spiritual leaders. They just tell them that no, the law just says that when you married, you must just get married in community of property and it's the right thing to do. And that to me seems like something that you can say is a good and justifiable reason if you've never understood the difference between getting married into community of property and getting married out of community of property. But on the latter one, the question is very interesting, but I'm just of the view that it might be a little bit selfish. I'm not I haven't seen case law yet on this, but it's something I will definitely look at tonight. But it's, to me, it will just seem a bit selfish.
Anyone to add? Yes, Ms. Rangwell.
I think that you wouldn't, if you were doing court papers, you wouldn't draw it up like that. You wouldn't say, well, we've got no creditors, or the creditors have no problem, but in future we might have and we want to get out of that. You wouldn't draw it up like that. You would draw it up something along the lines of, I am a business person and my wife is an independent young woman who has her own career, and at times we need to enter into independent contracts, for instance, to lend money or to sell assets, and while we're married in community, both of us have to sign, and that becomes very inconvenient and cumbersome. And so for these reasons, to facilitate our independent careers, we need to do it. You wouldn't straight out say, oh, we're scared of creditors.
Yeah,
but that's another answer, really.
Thank you for that.
I'm done.
Thank you for that. Rulani, are you happy? Was it your question?
Yes.
Okay.
Maybe with what Ms. Samuel said.
Okay. Any other question? Okay. So it seems we don't have any more questions, colleagues. I think seeing that tomorrow is a short weekend, I would propose that we stop here for today, and then next week we proceed to study unit 4. Please go through the study unit, prepare yourself so that you are able to meaningfully engage in the discussion. Thank you, everyone.
Thank you, ma'am.
Thank you.
Thank you.
Thank you. Have a blessed weekend. Thank you.
You too, guys. Bye.